Hello, my name is Sung Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bo-soo, we will cover the article published by Mail Daily, Mail Daily regarding the Supreme Court decision ruling regarding the wage peak system, which was agreed by the internal computer network is not legitimate. So could you explain the content or article, article, please?
Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today we had a very important Supreme Court ruling that was printed in this labor daily news. So the Lotte Shopping Company, they revised the rules of employment, especially they introduced the wage peak system. At the same time, they extended the retirement age from 57 to 60 in 2014. Actually, 4 years later, 2018, the retirement age rule was adopted in Korean labor law. So, however, this company, they introduced this wage peak system. Instead, they extend the retirement age from 57 to 60. So at that time, company received some consent or agreement from individual employee through the computer network. So they introduced the revised labor rules of employment and asked them to sign for their agreement. So 78% of all workers agreed on such a revised rules of employment, especially introduction of a weak wage peak system and at the same time extension of the retirement age. So in this wage peak system, they had to reduce their salary from 25% to 40% gradually from their age 57 to age 60. Yeah. So I think this revision, it was made based on the individual agreement through network their online services. So in this case, the Supreme Court ruled that when company intend to change the company regulation disadvantageously, they have to obtain the collective agreement in advance. However, this company neglect to follow this collective advance, but instead they received the individual agreement through online network. So online network based agreement cannot be accepted as a collective agreement. That is a basic concept of this ruling. Yeah. So this means when the Supreme Court ruled the revision of the working condition unfavorably, through the wage peak system, that is invalid, because they didn't receive a collective agreement from their workers. So since they received the individual agreement based on online network, so such a online the agreement cannot be accepted because it doesn't belong to collective agreement. So according to Article 94 of the Labor Standard Act, when company needed to revise company regulation disadvantageously, they have to obtain the collective agreement. That is what the Article 94 described. So this company, they neglect receiving the collective agreement. So I think the basic concept for determining or deciding working condition, they should be decided by mutual agreement on equal footing. So this concept is applied to the other common regulation like Article 94 when company revise the company regulation disadvantageously, they must obtain collective agreement from those who are related to this application. Yeah.
So the result of the Supreme Court ruling was because the final decision was made within this Lotte group because which is disadvantageous to individual workers. This is null and void because it should be based on the collective agreement by the labor union or representative. You're right?
Yes, right. Yeah. So to change the company regulation, we call it the rules of employment. They must maybe when it is a favorable revision, then they don't have to receive a collective agreement. However, when they revise the company regulation disadvantageously, then it is valid that they have to receive the collective agreement for the part they are going to change it. So then it is accepted as an agreement or change the rule justifiably. Yeah.
So because of this Supreme Court ruling, this Lotte group, they have to go through the ordinary procedure to negotiate with the labor union.
Yeah. So
Yeah.
to change the company regulation effectively, they must obtain the collective agreement. When they change the rule favorably or better than before, they don't have to receive a collective agreement. But when they revise the rule disadvantageously, they must obtain the collective agreement. That is what the rule is about. So this company, now from they introduced the wage peak system to those who get to the certain retirement age. So their retirement age was 57, but they agreed to extend the retirement age up to 60 years. So they extended the retirement age. At the same time, they adopted the wage peak system. So the company reduced their annual salary gradually from their age 57 to 60. So minimum is 25%, maximum was 40%. It was a very big disadvantage. So they had to receive some collective agreement, but they neglected it. So finally, company lost the case. Yeah, so that means they changed the rule disadvantageously, but they didn't receive a collective agreement. Then I think this case can be retroactively applied. So I think to introduce revised law effectively, they must have obtained some collective agreement in advance. Yeah.
I see. This court ruling can influence many other similar cases in future, I believe.
I think so. They must respect the basic concept of changing company regulation. Yeah.
Thank you very much.
Okay, thank you for watching. Okay, bye-bye.